I'm Teresa Coraggio, and this is Third Paradigm. I have been chomping at the bit to tell you the good news, but I didn't dare until the danger was over. My neighbor, who has not seen her 16-year-old daughter in 11 years since she and her brother were kidnapped in 2012 by the dad and his mom, has now been reunited. CPS has gotten nationally involved, flew the daughter back home on Friday, and the free legal services in 3 different states have come together, have written legally binding agreements, restraining orders against this severely abusive dad. And I'm going to link at the end my first episode on pedo-sadists and a call for help so that you can remember just how dire and hopeless and tragic this all was. And I will tell you, I am getting photographs every day, and I have never seen a happier and more radiant family. The little sister with a different dad, who is 6, has never met her sister, and the 2 of them now are best friends, and there are photos of them singing and giving piggyback rides, and just they are playing. And the daughter says, "Yes, I can celebrate. I could go for a run at 6 in the morning if I wanted." So there is so much joy, and I think we should be taking this as an omen for how everything that seems so impossible now is going to work out. And in the meantime, I'm going to go through the case files, because at the same time that the daughter was flying back, I was in the Fairfield courthouse ordering the case files. And when I have told the people there the story, I've been getting high fives through the safety glass, and they have just been cheering me on and absolutely so helpful. And when one of them, who had been there for a while, found out which judge it was, she said, "That figures." So this is a net that I am casting wide, and I do not think that these people know what's going to hit them. Let's do this. To refresh your memory, this is what I wrote in the first episode. I tell a personal and urgent story of a 16-year-old girl whose mom is my neighbor, who is in a dangerous and abusive situation where every avenue to go to an authority has been blocked. There is corroborating evidence that the dad, with a history of extreme violence, may be drugging her, going into her room, which only has a lock on the outside, forcing her to keep her curtains open for the registered pedophile and his adult male guest next door, and may even be trafficking her. So I transcribe in that episode the mom's list of injuries the dad inflicted on her, culminating in caving in part of her skull where it protects the spinal cord in 2011. When she got out of the hospital, she took the kids and went to a women's shelter in Washington State, and then lived with her mom, who moved there. But she called the dad every day so the kids could say goodnight to him, and in July 2012, she agreed that the dad's mother could take the kids to stay with the dad for a month and come back in time for the start of school. At the end of that month, he broke off all contact and never brought them back. Unbeknownst to the mom, the dad filed for dissolution of the marriage and full custody of the children in November of 2012. The judge in this case, Cinda Riggins Unger, has retired, but I've copied 15,000 words of complaints before they disappear from the Wayback Machine. This is one responding to a rare positive comment. The litigant below, I am glad your case was listened to. After all, it only took launching a recall petition, protest, and complaints into the Commission on Judicial Performance to force her to start looking at the facts instead of her own emotions. I have witnessed her in certain cases be very kind and speak in a normal tone of voice, then in the same breath scream at the top of her lungs over some misunderstanding. Your case may not have had these situations in it. Child abuse case where abuser wants primary custody. Domestic violence where the victim is blamed. Convicted felon awarded joint custody. Modification for the sole purpose to reduce child support despite child endangerment and abuse. Judge Unger has name-called, hit the bench violently, and knew her spouse, who is also a lawyer, was making money taking cases from her courtroom, because that's what everyone said. If you don't want to get her, hire her husband so that you can't get her court if you're a woman. In Solano County, lawyers tell litigants she's biased against women. If you're in her court, you're screwed. The first question I want to look at is whether the Fairfield Court in Solano County had the jurisdiction to decide custody. According to rightlawyer.com, the basic requirement for jurisdiction is residency. In a divorce, child custody, or family law matter, the court requires 6 weeks of residency to have jurisdiction over a divorce and 6 months to have jurisdiction over child custody or child support issues. Residency is not defined by your driver license or voter registration. To the family law court, residency is all about where you and children physically resided. The lawyer, in this case, fails to check the box that either petitioner or respondent has been a resident for at least 6 months. In the Uniform Child Custody Jurisdiction Declaration, the lawyer signs for the dad because he is absent from the county where such attorneys have their offices. He lists that as 1500 Webster, which I pass on my way to the courthouse, and that's the address that backs up his P.O. box. It's a very prestigious location around the corner from the courthouse. If the husband doesn't reside in that county, why would he be filing in this court with the judge notorious for favoring abusive dads? Pretty sweet location for an attorney with nothing online except one one-star Yelp review that says, "Very rude and impolite, very aggressive. At the end of the day, I would never recommend this attorney. His exact words, 'This is not a priority.' Not being very familiar with attorneys, I was referred by another attorney. Immediately he spoke over me and did not consider that I had just lost someone, which was the main concern for the call. Remember, it's how you speak to people that have no practice of the law. Remember, we are spending money." In the initial filing, the date of separation is listed as 2009, so married 7 years. The custody declaration has 2006 as the last year the kids lived with both parents in California, which is before the daughter's birth. It then skips 3 years and has them living with the mother in Washington in 2009 and then with the mom in Oregon until July of 2012. The filing, however, says the mom lives in Washington with no residence and moves frequently. It also says she's a citizen of Canada and Mexico, which was news to her. And it specifies that any change in the kid's residence must give the address to the other parent by certified mail with return receipt requested, which would have saved the mom 11 years of grief. Is that all a dad has to do to legally abduct kids? Say that the mom is living on the streets, God knows where. There is a summons and petition giving the mom 30 days to respond, or else the courts may make orders affecting custody of your children. It tells her how to get legal advice, but there is no document saying the summons was served. And by his statement, the kids had been with him for less than 5 months out of the previous 5 years. In addition, the dad signed that he'd read the restraining orders and understands that they apply to him when the petition is filed. These include removing children from the state without the prior written consent of the other party. So the court could never have accepted the case, and he was in violation as soon as he filed. Now we jump to Valentine's Day, the first time in the 7 months since the dad took the kids, or the 4 months since he filed for the divorce, that he has contacted her. He asked to meet at a McDonald's, and she is thrilled and runs to go buy them candy because it's Valentine's Day. And he laughs at her and says, "You don't need to do that," which in retrospect should have been a tell. She shows up, and there is some strange man who says her name and says, "Your husband is suing for divorce," pulls some documents a couple inches out of an envelope, and she falls to her knees crying, calls the husband, and he says, "You bitch, we're nowhere near Washington. I just wanted to get you where my lawyer could serve you." So the person doesn't leave any of those documents with her. This threw me because when I saw the document of the process server, it was registered by the clerk on February 22nd, and it looks legitimate. It has a stamp that says Unlimited Process Service with a Des Moines, Washington address. Bob Woodland is the server with a phone number and a 7-digit registration number. So why wouldn't he have given her the papers? Then I looked at another proof of service by Bob Woodland again, and I thought, those signatures, they look a little too much alike. No, they look exactly alike. And the stamp on it was tilted exactly through the line the same way. Why, the entire thing was a copy with the same date served and everything, except the lawyer had handwritten in 5 new documents. And this was stamped by the clerk on March 13th, so a different time. So did Bob go back in time to that crushing McMoment and say, "Hey, here's 5 more that I forgot"? And registered by the clerk also on March 13th is another from Unlimited Process Service for the same McDonald's on February 28th. This is by James M. Saylor, who curiously only has 6 digits in his registration number as a process server. He delivered the same documents that Bob did in his time travel, but he adds a declaration page for the Superior Court County of Salondo, spelling in context. He writes, "I served respondent custody papers for the law office of Daniel R. Long. She was happy and coherent, in my opinion. She had a backpack and looked unkempt. She stated that she was glad to receive the custody papers, so at least she knows what's going on at tomorrow's hearing. I pointed to the section where she could call in for the hearing. And this is declared under penalty of perjury. Is that a normal thing that process servers do? Get all chatty about the state of mind of the person that they just served? Maybe examine the papers ahead of time so that they know when the hearing is and how to call in. Such a helpful guy. Oh, and that address? It's a residential ranch home that sold in 2021 for unlimited process servers. I am glad that Bob and James could shack up and operate a business there before it sold, along with their time machine. So not only did our buddy James let the happy and coherent mom know when the court was deciding to permanently take away her kids, but the dad texted her, and his lawyer left a voicemail. All good. I've asked for the transcripts to see what this voice on the phone said. Now, 2 of the 3 court dates, she says that she doesn't still have the notes because these are just past the 10 years that they're required to keep them. So I'm hoping that that other person does. So I've asked them also, how do you verify that it is the correct person on the phone when they call into a court? And I haven't heard back from them on that. Whatever was said, the court took jurisdiction over the kids, gave the father full physical custody, and gave the voice on the phone a set time to call no more than once a day. So mediation is required before or during a child custody hearing, so the voice on the phone is cordially invited to participate on March 28th. This is an emergency hearing for sole legal and physical custody to the dad, who attached the following. Respondent agreed to give me the children because she was moving from place to place and has a drug problem. I believe she uses cocaine, meth, and or heroin, and that's spelled as the kind of heroin that she actually is, and abused prescription drugs. I believe she is suffering from delusions due to her abuse of drugs. On January 24th, 2013, I received a text from her stating she was dropped off in the woods at night and trying to escape from the Mexican mob. Respondent currently lives on and off at an assisted living residence. This residence is located at 3925B South Cloverdale Street in the worst part of Seattle, and drug deals occur routinely. She is unable to care for herself, much less our children. I live in a 4-bedroom, 2.5-bath house in Vallejo. Respondent is a drug addict and lives on the streets of Seattle. Her behavior is erratic and delusional due to the drug use. The husband misspells the wife's name 4 out of 8 times. I've looked up the house at that address, which sells for $800,000 in what looks like a nice housing complex, but since the wife was escaping horrific abuse, she never let him know her address. So this is as fictitious as everything else. In addition to Bob the time-traveling Valentine and James the Snoopy server, the grandmother who took the kids away also gave a declaration under penalty of perjury. She wrote, Respondent had moved to Vancouver, Washington in May of 2011. The children have chronic head lice. We treat them every time we have them, and they continued to suffer from head lice until our son gained custody in July 2012. We never received toothbrushes or hairbrushes. We have received the 5-year-old daughter in a diaper, which smelled as though she had worn it for days. The children have cried every time they have had to leave. Respondent has admitted to having to be in a protective mode due to the number of people who come over for parties at their house, and for having people live there that have just gotten out of prison, and for living with people who spank their children with belts. She's admitted to exposing them to a gentleman who is not allowed to be around children as he is a known drug user and dealer. The children have asked to take bar soap home, telling me They don't have soap or toilet paper. When I picked up the kids, respondent looked the worst I have ever seen her. She was approximately 80 pounds. Her clothes were dirty. She had one tooth left in her mouth, and it looked as though her gums were gray. The children were dirty, and their clothes looked like rags. They hadn't eaten breakfast or lunch. When we stopped at McDonald's, they ate 2 cheeseburgers. When I asked where they were living, the son said, "Under the stars, which is okay unless it rains, and then everything gets wet and it gets cold." Sometimes they stay with Grandma Doreen and her boyfriend in their trailer, and he likes to call the son Pissant because he's always bothering them. When we get home, I threw their filthy clothes in the garbage, and they returned to California July 28th, 2012. Well, that seems like a truthful, unbiased report to me, doesn't it to you? And when the mother calls into the hearing after all these friendly notices, she informs the court that she'll agree to the father having custody through the end of the school year. It makes it so much easier to do heroin without the little pissant around. And by the way, the mother's mother also is my neighbor, and her name is not Doreen. And her father was a minister. And after my friend's father died, her mother never wanted to date again. I could sooner imagine my mother dating someone who would call the grandson pissant than I could that sweet woman. That time travel machine is coming in really handy. On March 19th, the lawyer declared under penalty of perjury that he served the respondent with the grandmother's declaration for Solano County Court. Now, both the county name and the mother's name are misspelled. As he stated, he was readily familiar with the business practice of collecting and processing mail. However, he put the address of the respondent as simply B, South Cloverdale. Was he not familiar with the need for a number? Fortunately, he also sent it by email, and I am sure that that space between the first and last name wouldn't mess anything up. So he signed and filed that on March 20th. Then on April 9th, the lawyer was able to go back in time to March 19th and add 2 new documents, the mediation report and the supplemental report that it states are filed on March 26th. So he goes backward and forward in time. What a wizard! The county and respondents' names are still misspelled, and it still says that it was sent by email, but then lists first-class mail as the email address. This time, the mailing address is YMCA. The city of Seattle and the zip code seem to have been typed in later in a different font. It is a lazy man's forgery because all the lawyer had to do was retype it. He was the only one signing it and put in a new date. But why bother with that when you're already in so deep? This is filed with the clerk on April 18th. However, there is no mediation or supplemental report filed on March 28th. The court hearing summary says that the mediation did not take place with mother's participation due to miscommunication with the mediator. The case is sent back for mediation since a custody decision can't happen without it, and the court will review the mediator's comments on May 28th. So this is it. The final hearing to determine this as uncontested happens on May 28th. on that same day, an amended summons is registered with the clerk, notifying the respondent that she is being sued and giving her 30 days to respond. Like the original summons on November 2012, there is no proof of service claiming even that it was sent. There is also no mediation report ever filed or mentioned again. An amended petition is filed, but still doesn't check that the petitioner or respondent is a resident of the state or county. The date of separation has moved up by 19 months from the original, thanks to the time machine. Is that because of the 401k split by the time rule? Based on this, he had nothing to do with his kids while his druggy wife lived with them on the streets for 4 years, from the time his daughter was 1. And now he wants full custody? There is nothing fishy about that. According to his mother, the wife moved to Washington in May 2011, which correlates with the hospital records when he bashed in her skull. So all 3 of his own accounts have different dates of separation. The summary of the hearing states as follows. The mother is not present. Court finds service on mother is effective. Father shall have sole legal and physical custody. Mother shall have visitation supervised by the father. His attorney can write up the order and submit directly to the court for signing, no hearing necessary. But James Saylor of Unlimited Process Servers wraps this all up with a bright red bow. On August 10th, he serves the respondent with the amended summons that had given her 30 days from May 28th to respond. Although the hearing being that day, I'm not sure that 40 to 70 days too late really makes a difference. That and the amended petition are handwritten in, along with the lawyer's address above the Superior Court of Solano County with a different creative spelling, along with the respondent's name misspelled, of course. It also lists 15 more documents that were served at an address that I looked up and turns out to be a McDonald's, or had been. He declares under penalty of perjury that he delivered these to her and left them with her after she read and signed another set of the same documents in front of him. I hope he was buying the coffee. Typed into the document is signed at Des Moines, Washington on September 13th, 2013. Over a month later, the agreement that it's uncontested and waiver of appeal and waiver of disclosure are signed in the respondent's name and dated August 10th in a different handwriting, which also is what is dating the husband and attorney's signature as September 18th. The marital settlement agreement is signed in her name, although it's missing 2 to 4 pages. This is also signed by the husband, the lawyer, and then the judge, and then filed. So here's what I know from my own divorce agreement. You have to get at least a week in between getting the completed MSA and when you sign, so you have a chance to look it over thoroughly and to consult a lawyer. You also have to initial every page, which has to be numbered as 1 out of however many. This does the 1 out of however many, but it also is missing either 2 or 4 of them. And there are no initials on the pages. And then it has to be notarized. Of course it has to be notarized. And a process server who gets a license for $10 is not a notary. So this is something that the judge signed, looking at a signature with absolutely zero evidence that that was actually the person signing away custody of her children. So is that all an abusive husband has to do in the Solano court? Say, my wife, she's living in a dump. Here, I'll just throw this summons in the trash and I'm sure it'll get to her. Only a vindictive judge with malice against mothers could have believed the over-the-top fabrication by the dad's mother that the kids cry when they have to leave and beg for soap and toilet paper. It is a completely idiotic, made-up story. From the date of filing, this was in violation of the Uniform Custody Act, and the police should have been notified in both Washington and Oregon states, listed as the mother's last address, to find out if missing children reports had been filed. The blatant falsification of proof of service, the use of obviously bogus mail and email addresses, and the nonsensical acts performed by process servers, all were clanging alarm bells ignored by the judge. She gave away custody of a mother's children with zero verification that the mother even knew where they were. It is beyond gross negligence, and it is an accessory to kidnapping. From the consistency in the complaints against that judge, I think every ruling she has made against a mother should be declared a mistrial. Then the grandmother should be charged with kidnapping, perjury, and defamation. The lawyer adds fraud to that list. And the evil stepmother, who likely pretended to be the mom on the phone, is also implicated, although the daughter has charges of her own that she wants to bring against her. On the income and expense declaration, she's listed as the financee, which probably means fiance, but is a Freudian slip. And as for the husband, I'll add one last cherry on top. When the mom was doing some research through Veterans Affairs, what she found out is that he took out life insurance on her 3 days before he bashed in her skull. So that is premeditated, attempted murder. And I can't wait until I can share their real names and some of these photographs that are just making me insanely happy. But you should look at how far this has come, because it is such a miracle story. So here is the original Pedo Sadist and a Call for Help, and this is the other one on the FBI's War on Moms. Thank you for watching and sharing in this journey.